Greetings! Welcome to episode 3 of this Courts and Trials series on the criminal court process and whether it provides an illusion of justice or not. Today we make the transition to the first of 3 parts looking at the court actors. Our first look is going to be at defense attorneys. Think about this for a moment. If you were charged with a criminal case, with a criminal offense, you had to go get an attorney to represent you. What would you want that attorney to do for you? The Sixth Amendment provides that everybody has the right to the assistance of counsel for their defense. In 1961, the United States Supreme Court, in the case of Gideon versus Wainwright, interpreted this to mean that the state must provide counsel to those who cannot afford it. This had the effect of creating 2 different types of defense attorneys. The first is the public defender. These are people provided by the state to represent those who cannot afford an attorney on their own. The second is a private defense attorney. This is somebody who the defendant pays to represent them in court. These distinctions are very important when we look at representation and the work that defense attorneys do, because public defenders and private attorneys are perceived differently. Let me give you an example of how this works. So you are standing up in front of court and you're at the arraignment where the judge is telling you the charges. And after the judge tells you that you've been charged with the crime, the judge will ask, do you have an attorney or do you need a public defender? Right away, by simply asking that question in that way, the judge is drawing a distinction between public defenders and private attorneys. The judge is saying that public defenders are not actually attorneys. They're someone who is just there to appoint you, and that really what you need is an attorney. This misconception then follows throughout the process. Defendants who have public defenders see themselves and see their representative as different than if they had the own attorney that they chose, that they hired. Public defenders are responsible for defending most of the defendants that come through the criminal court process. In fact, it doesn't take much searching to find that many states are in a public defender crisis, where public defenders just have too many cases in order to adequately represent those whom they are assigned. There are 4 different types of systems that different states may employ to provide public defenders. The first is what we call a public defender system. This is a state-run agency that has offices in every jurisdiction in that state, and the attorneys in that jurisdiction will represent the defendants who are accused of crimes in that jurisdiction. And there's a bureaucracy and a hierarchy that goes with it, all the way up to where you have a state public defender who is responsible for overseeing the entire system. The second system is what we can call a list system. This is where the court maintains a list of defense attorneys. That may be people who volunteer to be on the list. It may be people who are simply attorneys that work in that jurisdiction and are subject to being assigned to a particular case. The court will simply go down that list, one attorney at a time. As a defendant comes up, they go to the first attorney on the list. The next defendant gets the next attorney on the list. The next defendant gets the attorney after that, and so on. The third system is what we can call a law firm system. This is where a private law firm will contract with the state to provide public defender services in that particular jurisdiction. When this occurs, generally what that means is There will be one firm in that county, and that was all the work they're going to do. So if you are in Midlands County, then you would have this one law firm in Midlands that will represent you in the case. Finally, we have a hybrid system. This is going to be a combination between the list system and the public defender system. In this system, you have people who work part-time for the public defender, and they will get cases and get paid based on the number of cases that they handle, and so they get paid on a per case basis, or perhaps they get a small salary through this process. So it's a sort of a volunteer list system, but there is a set organization structure around it. There are two key problems that the public defenders face. The first is high caseloads. It's not uncommon for public defenders to have 60, 70, 80 different clients at a time. Some may even have more than 100. If you think about what you want your attorney to do, some of those things may be they want to visit you in jail. You may want them to investigate the case. You may want them to be prepared when they come into court and present your side of the story. If a public defender has 15 different cases that are scheduled for that particular week, how much time can the public defender spend working on your particular case? And so high caseloads is one of the number one problems faced by public defenders. The second is that perception that we discussed earlier, that they are not real attorneys. Their clients don't trust them as a result. The clients won't do what the public defender says. And as a result, there is a lot of friction in the attorney-client relationship, which again tends to provide a disservice for the client. Apart from public defenders, we have private attorneys. And private attorneys are those that you pay for. And so there is a belief that if you pay for that attorney, it must be someone who is pretty good and that they have an interest in working for your benefit and helping you, rather than a public defender who will get paid no matter what. The problem is that private defense attorneys are a for-profit enterprise. They need to be able to survive as a business, which means that they have to constantly get new clients and get new business. And so time that they spend in court is time that is taking away from their ability to get new clients. As a result, as one observer mentioned, private attorneys can almost be like confidence men, where they are gaining the trust of their clients, but then selling out their clients later on down the line, not delivering all it is that they promised. The equation is very simple, right? Defense attorneys need more cases so that they get more money, right? More cases means meeting with clients. It means advertising. It means distributing your business card out to those who might need it. If you are in the middle of trial, or if you are meeting with a particular client, you cannot do that. As some defense attorneys have said, going to trial is an economic loser for them. They also must be responsive to clients, because there are many different private attorneys out there. And because you are working for this paying client, that paying client may say, look, I'm going to take my business elsewhere because you're not responding. And so there's lots of pressure to respond to all of these clients. All of this leads to a major incentive on the part of the defense attorney to have their particular clients plead guilty. Again, going to trial is a losing financial proposition. If you can lead them to the point where they plead guilty, then you have had a successful outcome from the private attorney perspective. Let me sort of break this down for you. Again, going back to Jerry Buting, who was the defense attorney in the Stephen Avery case. In his book, Mr. Buting says that for every hour he spent in court meant 10 hours of preparation time. Right? The cost alone of that trial exceeded $2 million. Attorneys private attorneys simply can't invest that much. Mr. Avery was not paying for $2 million worth of defense. Mr. Buting's other clients potentially suffered while Mr. Buting was devoting all of his energy to Mr. Avery's case. And so private defense attorneys must create some sort of balance to where they can adequately defend their clients' interests while at the same time make sure their private firm has enough money to survive. This raises the question of defense attorney ethics. What are defense attorneys supposed to do? Are they supposed to get their client out of jail? Do they only win when the client is found not guilty? Or do they win when they get a really good sentence from the prosecutor or from the judge? Should they try and get the case dismissed? Or is it enough that they effectively represent their client, present their client's case, and even if the client is found guilty, as long as all of the client's rights have been protected, then the defense attorney has done his or her job? The key for defense attorneys is that they do represent their client. And many clients have positions that are not popular. Right? They may think their conduct is justified. They may have racist views. They may have opinions about the victim that would not be welcomed by many. Nonetheless, the defense attorney must represent those views, even if the defense attorney finds those views appalling. This makes it very challenging for defense attorneys at times. You have to put your own views aside, interests of your client. But what are the client's interests? Does the defense attorney put what the attorney perceives as the client's interests above what the client wants? For example, suppose you have a defendant who has had 2 prior drug convictions. The defense attorney knows that if the defendant pleads guilty to a 3rd drug case, that will subject the defendant to potential federal criminal prosecution in the future. Is it better to have your client go through forced drug treatment or maybe go to prison for a period of time to learn what that's like, rather than simply get the client probation, which is what the client is going to want? Must every client receive the same treatment, or should you treat every client on a case-by-case basis? What if you have some clients that are guilty and then some clients that are innocent? Should you approach the defense of that case differently? Right? If your client is in fact guilty and admits guilt to you, do you simply plead them guilty for whatever you can get and go on to the next? Do you spend extra time with an innocent client to make sure that that innocent client doesn't end up wrongly convicted? These are difficult challenges that defense attorneys must address. What about sacrificing one client that you know is guilty in order to work harder for another client? Or maybe not pursue a borderline claim so that you can build up credibility for a later case when you actually raise that claim. And again, difficult ethical questions for attorneys. Defense attorneys must also figure out how they're going to interact with their particular client. And research shows that there are 2 different ways that attorneys will do this. One is going to be recommending, another would be advising. Right? So when you recommend something, do you simply give the client the choice, lay out all of the options and say, look, you can either go to trial, you can plead guilty, you can sit here and wait for potential dismissal, you can hope a witness dies, right? All these different options are available to you. Do you simply lay them out and let the client decide? We would call that recommending. We'll say, look, I recommend you do this, here are the other options, it is your choice. Right? Generally, public defenders are going to follow this process because the client already doesn't trust the attorney And so if the client wants to develop a sense of trust, then you have to give that client some control over the outcome of the case. Other attorneys are going to say, no, I'm the attorney, I know better, I work in this system, I'm going to advise the client what to do. So I'm going to say, look, this is where we are in the process, this is what you're up against, this is what we are going to do, right? Here are some other possibilities, but we are going to go this way. Essentially, you are telling the client what it is that is going to happen. Again, private attorneys have a little bit more ability to do this because the defendant has put money on the line, right? They paid $5,000 for this representation. By definition, almost, they're going to do what the defense attorney tells them to do. So that raises our final aspect of criminal defense work. If the Sixth Amendment guarantees the right to counsel, does it guarantee the right to have good counsel? What if your attorney is terrible? What if your attorney makes bad decisions? What if your attorney gets up and in closing argument has a legal pad and is reading the closing argument to the jury? Do you have the right to have bad counsel? How do we know that counsel is effective? Well, the U.S. Supreme Court has answered this question. They said that the right to counsel, if it means anything, means the right to effective counsel. And they said effective counsel can be defined by looking at two different things. The first is, did the counsel's performance fall below reasonable professional standards? What exactly this means may vary from place to place and time to time. But we know that if the attorney failed to follow the guidelines of professional responsibility or the rules of professional responsibility, then that would be sufficient to fulfill that particular test. The second part of that test, however, is that the outcome must be affected, that there's a good probability that the outcome would have been different but for the defense attorney's ineffective conduct. This is much harder to make, especially if you believe that there's probable cause to believe that just every criminal defendant charged with a felony is in fact guilty. And so therefore we have to consider what are the chances of any defense attorney getting a different outcome other than a guilty plea, especially if only about 2 or 3% of all criminal cases end up with a not guilty verdict. This is a really high standard to meet and really doesn't tell us much. But nonetheless, we need to think what we want our counsel to do. Is it simply to get a not guilty verdict? Or is it the least amount of jail time? Or is it getting the case dismissed? Or is it having the defendant placed on probation, getting treatment? Right? Before we find out what effective counsel is, we have to understand in our minds what it is we want the defense attorney to do, whether that defense attorney is a public defender or a private attorney. And all of that goes back to the question that we started with. If you were charged with a criminal offense, what would you expect your attorney to do for you?